Of course, I had included some slides that in part overlap with what was the presentation before me, and therefore, don't worry, I will skip them and go quickly, passing to the next one. But because as it was introduced, I am going to talk about the next level, which would be the criminalization of the provisions regarding violations of international humanitarian law. Of course, my starting point is also international humanitarian law, and in particular, of course, the Geneva Conventions and the associated regime. And I had started with a slide that I normally use also with my students in the university. Sometimes it's nice to give a face to some people that have left such a huge legacy for us in our world. And this is Henry Dunant, that you probably already heard of, the Swiss businessman who, after the Battle of Solferino, where he had the chance to see the horrors of what was left on the field in that battle in the 19th century, and he was so shocked that then started to work in order to create a relief organization that was thought in reality for the wounded and sick on the field, so the soldiers, but then developed to be the International Committee of the Red Cross. And he was the recipient of the very first Nobel Prize in 1901. From then, of course, a lot of development happened, which were already brilliantly told you by Ali before me. And so this development of international humanitarian law along the two lines that were already described, Geneva and The Hague, it's clear we don't need to go again through these. But what I want to highlight is that there is still a very, very strong tension between the two main components of this field, this branch of international law. On the one side, the military goals of the war in itself, and on the other side, the humanitarian considerations. And so this branch of international law is really very complicated, especially today, in front of the basic principles that we also have already heard of, to be applied in the context of our contemporary conflicts, asymmetrical conflicts, where very often it's not even clear whether there is a state of war, and it has been blurred, the very confined, the very border between what is a situation of war, which already started, and the waging of the war, where in international law you have different legal regimes applying to the one and the other. And in one case, the criminalization of international humanitarian law is the war crimes regime, and in the other case is the crime of aggression. So for my presentation of today for you, I will only focus on the war crimes regime, so the criminalization of international humanitarian law. And here again, we go to the Geneva Conventions that were already introduced by Ali. And in particular, we focus on one specific aspect of the Geneva Conventions, which is the grave breaches. So as you have heard, in each and every Geneva Convention of 1949, there is one provision that criminalizes particular violations of the Geneva Convention itself, the specific one, as grave breaches. And for each of the Geneva Conventions, the article which criminalizes these violations has a different number. In the first one is Article 50, as you can see in this slide, I just summed it up. The Geneva Convention second is Article 51, For Geneva Convention 3 is Article 130. For Geneva Convention 4 is 147. And in the Geneva Convention 4 is, and for Additional Protocol 1 is Article 85. We don't have any provision regarding the grave breaches in our Additional Protocol 2 because at the time when it was drafted, the idea was still that the grave breaches regime had to do with international armed conflicts, and there was just one provision that is Common Article 3 in the Geneva Conventions regarding non-international armed conflicts. So what does it mean that we have this kind of regime, the grave breaches regime? It means that certain violations, because they are particularly grave, require states to take appropriate action under domestic law. In particular, states are obliged, according to these provisions, which are identical, even if the numbers change in the 4 conventions and in the additional protocol, they are obliged to undertake to enact any legislation necessary to provide effective sanctions, criminal sanctions, for those who commit, order, or participate in any of the grave breaches of the convention. And moreover, each high contracting party, meaning each state, shall be under the obligation to search for those who are alleged to have committed or, again, have ordered to be committed such grave breaches, and shall bring such persons, and this is very important, regardless of their nationality, before its own courts. So there is also an alternative. If the state is required to extradite these suspects which are found on its territory, it may also do so, if you see the language, if it prefers. So there is an obligation that in Latin is expressed traditionally as the obligation of aut dedere, aut judicare, meaning states have an alternative, which is either they proceed with regard to the suspects of the commission of grave breaches, meaning war crimes, before their own courts, or they extradite the suspect to another state which possibly asked for this extradition. So what is clear is that states don't have the opportunity just to stay put and do not do anything. So this is not something that states can do in front of the Commission of War Crimes. They have to undertake action. In the first place, provide for the criminalization of these conducts in their own domestic legislation, and second, enact, so enforce the legislation when a suspect of these violations, of these crimes, is found on their territory. And by the way, there is also, as we said, an obligation to search for these suspects. So these Geneva Conventions of 1949 are the first treaties that require such criminalization of certain violations of international humanitarian law. And from 1949 till today, this law of war crimes has evolved, and the principle is firmly settled that certain violations of international humanitarian law entail individual criminal responsibility directly under international law. And these are exactly what we call the war crimes in international law, and are under the jurisdiction of international criminal tribunals, but also under the jurisdiction of domestic criminal tribunals. The fact is that sometimes it's not that easy to understand, determine which violations of international humanitarian law create such an individual criminal liability. And indeed, historically, it has been one of the main challenges and is still in a way one of the challenges faced by judges to understand what provision creates direct criminal liability on individuals in international law. Because this is something that needs to be said and to understood very clearly from the beginning, that international law and particularly international criminal law develop, evolve, change. They are subject to a process which brings new war crimes. And one of the things, for instance, that happened is that with regard to certain war crimes that were only relevant if committed in the context of international armed conflicts, now they are also recognized as relevant in non-international armed conflict, meaning internal conflicts, as we were hearing before. Most of the conflicts today is of a non-international nature, and that's why it is so important to recognize which war crimes apply in this context. So, just to repeat a concept that I find really crucial to understand for maybe those of you who don't have basic knowledge about this. In international law, we have two different parallel responsibilities. On the one hand, there is the responsibility of states that is not criminal, it's a civil liability for the commission of war crimes, grave violations of international humanitarian law. But at the same time, and this is what we are talking about specifically in my presentation, there is a parallel responsibility of individuals, and this parallel responsibility of individuals is of a criminal nature. So we should see international criminal law as an enhanced, a stronger level of protection, and also as an enhanced mean of deterrence. So the violations of international humanitarian law will not only be entailing a responsibility of states, but also will be criminally prosecuted, meaning that the individuals who are responsible for them, and we will talk about this in the second part of my presentation, who are these individuals, can be criminally prosecuted, and of course, upon them, a criminal sanction, in particular in the form of imprisonment nowadays, can be imposed. So the first example of this, we have it in Nuremberg. As you maybe know, in the Nuremberg Charter, after the Second World War, of course, 1945, there was an article which was criminalizing war crimes, and this was the language that was used at the time: war crimes, violations of the laws of customs of war. And these violations shall include, but not be limited to, murder, ill treatment, deportation, slave labor, or for any purpose of civilian population in or in the occupied territory, murder or ill treatment of prisoners and persons on the sea, killing of hostages, plunder of public or private property, wanton destruction of cities, towns or villages, or devastation that is not justified by military necessity. So we have a sort of catalog, a first catalog of what are the war crimes entailing individual criminal responsibility. And you see it's a bit rough still, the way it is, so to say, codified. It's not a real codification, of course, it's an international instrument, but we have already in a nutshell, already in 1945, we have in a nutshell the concept of what would then become war crimes in a much longer provision that is now included in the Rome Statute of the International Criminal Court. So from Nuremberg, I'm going very fast. Of course, there would be also other steps in between, but we jump passing from the ad hoc tribunals, which I don't mention, we jump to the Article 8 of the Rome Statute of the International Criminal Court. And even if we cannot say that it is an international criminal codification, still, in the Rome Statute, in Article 8, if you take it, you will see it is several pages of listing of war crimes. There is a catalog that is definitely very comprehensive of what nowadays are considered to be war crimes. This doesn't mean that other war crimes might also exist in the development, which of course it's always ongoing under international customary law. But for the purposes of the Rome Statute, which means for the jurisdiction of the International Criminal Court, Article 8 is authoritative. In the first place, the judges will have to apply the statute. In particular, it is said that these war crimes become relevant when they are committed as part of a plan or a policy or as part of a large-scale commission. We don't have the time, of course, we don't want to go into the detail of Article 8, which, as I said, is very, very long. I just mentioned the structure of it, which is quite complicated. The article is divided in two basically main parts. Each of them has two subparagraphs, so there are four subparagraphs. The first two have to do with international armed conflicts, and the second two have to do with non-international armed conflicts, and they in a way mirror each other. But still, the structure that has been adopted in 1998, so quite a long time ago, 25 years ago, by the statute drafters, still has this distinction in the structure, which is on the one hand the grave breaches of the Geneva Conventions for International Armed Conflicts and other serious violations of the law and customs of war, also for international armed conflicts. And on the other hand, the serious violations of Common Article 3 to the Geneva Conventions, which is, as I said, the only provision in the Geneva Conventions regulating non-international armed conflicts, and other serious violations of the laws and customs of war for non-international armed conflicts again. So this is the structure of it. And in this structure, we can identify the elements of what are the war crimes. And I tried here in this slide to summarize what are the common elements of the war crimes. So this is in a way an analysis that can apply to each and every war crime that we will after quickly have a look to. So in the first place, to have a war crime in international criminal law, and specifically for the sake of the jurisdiction of the ICC, you need to have a context. And of course, the context is the armed conflict, right? So the armed conflict that can be, as we said, international or also non-international, is what is happening. And in this context, individual acts, so specific violations of international humanitarian law, are committed, the specific war crimes that we are talking about. And they are committed not just during, but with a nexus to the armed conflict. So there is what is called a so-called nexus requirement. And also, of course, these individual war crimes need to be committed with intent and knowledge. So meaning that the person, the soldier, the commander, the general who's committing the crimes must have the mental element. So I skip this because in a way I already said, and also Ali before me already said, that there is this problem about the interpretation of what is international, non-international armed conflict. So my bottom line here is that in the end is not that relevant anymore with regard to the war crimes regime to distinguish between international and non-international armed conflict. Why is not that relevant anymore? In particular, because already 20 years ago, the International Committee of the Red Cross, in a very important study on customary international law, concluded that most of the rules of conduct that apply to international armed conflicts nowadays apply also to non-international armed conflicts under customary law, regardless of what is written in the Geneva Conventions or in other treaties. What does it mean? It means that the violations of these rules, customary law rules, by definition, has as a consequence the fact that these are war crimes also if they are committed in the context of non-international conflict. So regardless of how you would interpret, including judges, for instance, the situation in Gaza, right? The conflict that is considered to be among a state, Israel, and a non-state actor, Hamas. Some would say that it is an international conflict, and I think it's correct because Hamas, of course, is a Palestinian armed group, but the whole conflict is happening in a context of occupation, which triggers the international armed conflict regime. But others would claim that it's not, because Hamas is not a state actor, and therefore, according to different definitions of an international armed conflict, this would not fit into that picture. But again, I repeat, the bottom line is that regardless of these distinctions, war crimes committed in international or non-international armed conflicts, in the end, nowadays, basically, are under customary law the same, in the sense that in both cases, they imply the individual criminal responsibility of those who commit these crimes. That's why, in my opinion, it's much better to distinguish war crimes not like the Rome Statute does according to international, non-international conflicts, but according to what is the protected value. So there are crimes, war crimes that deal with the protection of persons and property, and crimes that deal with, for instance, the prohibition of certain means of or methods of warfare. And here I just skip these slides, but they are in the presentation, so of course you can go back to them. Here I propose, following also the German distinction on these war crimes, a different categorization. And you see there are crimes that are involving killing the persons or mistreatment, sexual violence, slavery, forced labor, intentional targeting of civilians, of course, but also child soldiers. All these crimes have to do with crimes against persons, and others that have to do with property. So, for instance, the destruction of civilian property, of buildings or civilian infrastructures, and others that have to do with prohibited methods of warfare. And one of these important war crimes has to do, of course, with something that we are talking a lot in these months, in these horrible weeks in particular, that is the crime of starvation that applies in the situation of Gaza. And if you know, there is a warrant of arrest that has been issued by the International Criminal Court last November on the 21st for the Prime Minister of Israel, Benjamin Netanyahu, and the former Minister of Defense, Gallant, that includes also the war crime of starvation. In particular, there is a warrant of arrest that includes the press release by the International Criminal Court that refers to the situation in the state of Palestine, the warrant of arrest I was mentioning. And in this warrant of arrest, issued last November, there is a part that is dedicated to the crime of starvation. And therefore, I just wanted to show you this part. And here it is. The chamber found reasonable grounds to believe that Mr. Netanyahu and Mr. Gallant bear criminal responsibility for the war crime of starvation as a method of warfare. The chamber found that there are reasonable grounds to believe that the lack of food, water, electricity, and fuel, and specific medical supplies created conditions of life calculated to bring about the destruction of part of the civilian population of Gaza, which resulted in the death of civilians, including children, due to malnutrition and dehydration. On the basis of material presented by the prosecutor covering the period until 20 of May 2024, the chamber could not determine that all elements of the crime against humanity of extermination. And then there is one other very relevant part, I believe, for what's happening at the moment, that is, in addition, by intentionally limiting or preventing medical supplies and medicine from getting into Gaza, in particular anesthetics and anesthesia machines, the two individuals are also responsible for inflicting great suffering by means of inhuman acts on persons in need of treatment. Doctors were forced to operate on wounded persons and carry out amputations, including on children, without anesthetics, and or were forced to use inadequate and unsafe means to sedate patients, causing these persons extreme pain and suffering. And this amounts to the crime against humanity of other inhuman acts. So I was mentioning the fact that in these warrants of arrest, the crime of starvation has been charged with regard to the leaders, to the two prime minister and minister of defense of the state of Israel. And in particular, this crime has been charged for them as co-perpetrators, meaning that they really took the important actus reus, the conduct, they put in place the elements of these crimes. But this is not the only way to attribute individual criminal responsibility in international criminal law, and specifically in the Rome Statute, under the Rome Statute of the International Criminal Court. So again, just making it really basic, very simple, there are different forms of participation according to what is provided for in Article 25.3 of the Rome Statute. And these are commission, instigation, ordering, assistance, contribution to a group crime, or also incitement to genocide and attempt. But there is also Article 28 of the Rome Statute, and this is what I would like to focus in the remaining literally 5 minutes at disposal I have, that is called command responsibility. Why is command responsibility important? Because it's a mode of liability that makes the superior, the military commander, but also the civilian superior, responsible for the crimes committed by their subordinates, not for something that they did, not for ordering, not for participating in the crime, not even for instigating or planning them, but for something that they failed to do, a failure to act. So superiors are responsible for the crimes committed by their subordinates, also if they violated their duties to control, to prevent, and to punish. And these duties are directly imposed by international humanitarian law in the first place with regard to the war crimes that we are talking about. So why is this mode of liability so important for the topic of today? First of all, it is really embedded in the military structures. It is one of the original creations of international criminal law that comes directly from international humanitarian law. It is rooted in the hierarchical organizational structure that is typically to be found in the context of commission of war crimes, meaning during armed conflicts, during these broad contexts of war. And it is a useful mode of liability that has been used in the past, not so much until now by the ICC, but as I mentioned, we have seen it now in the warrant of arrest for Netanyahu, and we have also seen it used in the warrant of arrest for Putin, so the highest leader of the Russian Federation, for the crimes committed by the soldiers, by the subordinates, even when there is no evidence of any contribution in terms of action by these leaders to the commission of the crimes on the part of their subordinates. So this doctrine is a very ancient one in military fields. Even some scholars trace it back to this Chinese military manual that was 500 years before Christ. So a very ancient, the Sun Tzu, famous Sun Tzu Chinese military manual, which was already talking about the responsibility of the commander when the troops are insubordinate. It was saying it's the fault of the commander. But also in the aftermath of the Second World War, there was a very famous case that had to do with this liability regarding the General Yamashita, that was a Japanese imperial army general that was convicted for the crimes of his troops during the Filipino, in particular, part of the war. And after the Yamashita trial, we got the first codifications at the international level. And the most important one is to be found in Article 86.2 of Additional Protocol 1 to the Geneva Conventions of 1977. This provision already contained the principle that when there is a breach of the conventions or of the protocol that is committed by a subordinate, this does not absolve the superior for penal or disciplinary responsibility if the superior knew or had information which should have enabled the superior to conclude in the circumstances at the time that the subordinate was going to commit or was committing such a breach and did not take all feasible measures to prevent or repress the breach. So what you can notice is that at the time in 1977, the Geneva Convention, the additional protocol, was not clearly talking about criminal liability. It was penal or administrative. And it's only with the ad hoc tribunals then we have a clear criminal responsibility for this mode of liability, for this failure to control and failure to take the necessary and reasonable measures to prevent such crimes committed by the subordinates on and therefore implying the superiors or the commander's responsibility. But it is only with the ICC statute that we have a full-fledged definition of this mode of liability that is also clearly now attaching also to the civilian leaders. Again, I skip the long definition that you will find in Article 28, but I just want to mention the three elements of this responsibility. Of course, there must be a superior-subordinate relationship. Also, there must be an element at the subjective element, which is that the superior must know or should have known, so negligently failed to know that the subordinate was about or had committed a crime, and this important conduct, which is the failure to take the necessary and reasonable measures to prevent the commission of these crimes by the subordinate. So here you will find in the slides some more details about these three elements, which I skip for now. And to conclude, again, I would like to mention the part of the arrest warrant for Benjamin Netanyahu and for the defense minister of Israel, Gallant, that involve this mode of liability. So in the press release that was issued by the ICC, the pretrial chamber, on the 21st of November of last year, it is said that with regard to the crimes, the chamber found reasonable grounds to believe that Mr. Netanyahu, the Prime Minister of Israel at the time of the relevant conduct, and Mr. Gallant, Minister of Defense of Israel at the time of the alleged conduct, each bear criminal responsibility for the following crimes as co-perpetrators for committing the acts jointly with others, the war crime of starvation as a method of warfare, and the crimes against humanity of murder, persecution, and other inhuman acts. And then the judges add, the chamber also found reasonable grounds to believe that Mr. Netanyahu and Mr. Gallant each bear criminal responsibility as civilian superiors for the war crime of intentionally directing an attack against the civilian population. So you see, specifically with regard to the intentional directing of attacks against the civilian population, there is this recourse to Article 28, which means that the two suspects are found to be responsible as civilian superiors for not having taken the necessary and reasonable measures in order to prevent or punish specifically this crime of attacking intentionally the civilians. And I also would like to stop here, and I, of course, remain at disposal later in case there are questions or clarifications needed. Thank you.